social media disasters, which I'm sure everyone's really interested in hearing more about, especially because it's gained such attention in recent months in the media. I'll just introduce Newson Ainsworth. He's a passionate and regular presenter on incorporating technology and social media into legal and professional advice industries. Newson practiced as a solicitor in a Melbourne commercial law firm prior to his appointment to Victoria University as a lecturer in law. I now invite Newson to mediate the panel.
Social media in law is rapidly developing and creating new and interesting benefits, ethical issues, and causes for concern, and for today's purposes, disasters. The LIV Ethics Committee hotline receives about 3,000 calls a year. Of those calls, only a handful are social media related. I can only think of two reasons why this is so. One, social media, and with that technology, are conservatively utilized by the legal profession, and two, lawyers are not aware of the reality of the legal implementation. Everyone knows the word I'm trying to say, right? Okay, we'll move on. That social media can cause. A 2012 report by the International Bar Association stated that every actor in the legal arena has felt some effect of online social networking on the daily practice. At present, the corresponding standard of appropriate or acceptable behavior in such areas is somewhat contentious and unsettled. Results of the survey which fed that report were that 80% of survey respondents stated that currently the legal profession in their area are not adequate. The legal professional codes and guidelines are not adequate for applications to social media and need to be updated. The Law Society of England and Wales stated when engaging in social media, a fundamental consideration is the blurring of the boundaries between personal and professional use, and the importance of recognizing that the same ethical standards and obligations apply to professional conduct in an online environment. The fact is that social media is here to stay. There are huge benefits from the user. In my opinion, the biggest social media disaster today would be the failure to use and reap its benefits. I'll turn over to the panel and start with Leigh Howard. Leigh is a solicitor practicing in workplace relations, employment and safety at Clayton. He is also a pro bono coordinator at his firm. Leigh holds an honors degree in law and a bachelor's in international relations from Latrobe University prior to joining Clayton.
My purpose today is to talk about social media disasters in the employment law space. Social media impacts upon employment law. It's a very interesting and important phase. There are many cases where an employee has done something allegedly repugnant to their contract of employment when using social media, subsequently been dismissed, and then challenge that dismissal at the Fair Work Commission. First, these cases confirm that an employee may be disciplined or dismissed if they use social media in a way that injures an employer's interests. Second, it is no defence that employees' privacy settings are being used. Social media users are still viewed as publishers in the public realm. Third, employers are increasingly expected to regulate social media activity through HR policy and training. Social media also impacts upon occupational health and safety duties. In the age of trolls and cyberbullying, what these duties precisely require makes for interesting conjecture. Under Victoria's OHS Act, employers must provide and maintain a working environment that is safe. At a minimum, therefore, I think the OHS Act requires employers to monitor situations where social media use is being used on behalf of the employer as a part of employees' duties. I believe that the OHS duty would require an employer to monitor their social media presence and identify this type of conduct, take steps to eliminate it and minimise it, train their marketing and PR employees how to deal with it, make counselling and related resources available when they are subject to it, and ultimately ensure that those who are entrusted with using social media on behalf of an employer have a thick skin. HR policies addressing social media conduct is the key way to ensure that reasonable precautions and due diligence or reasonable practical steps are taken to minimise social media disasters. I imagine that social media policies are set to become a lot more complicated. Thank you.
The next panel to share is John Fogarty. John is a senior associate. John has worked for a range of government and corporate clients in a variety of proceedings in the county court, Supreme Court, and federal court.
So I'm going to talk about your liability for posts that other people put on your social media pages. Allergy Pathway and Mr. Keir said, okay, I can be responsible for things that I post on my Facebook page, and I can be responsible for the things that I publish on my website, but I shouldn't be held responsible for statements made by my clients or Facebook friends. There was also a lot of negative publicity, and ultimately all those things came together and ended the business altogether. So what's happened since then? Well, there's been 2 Advertising Standards Board decisions which has applied the case. The Advertising Standards Board applies the National Advertisers Code of Ethics. The board determined that a Facebook page is a marketing tool which the advertiser has a reasonable degree of control over. The Advertising Standards Board code therefore applied to Facebook pages. The other recent development is the ACCC's publication of guidelines for the use of social media. The clear message is be vigilant. The degree of vigilance will depend on the size of the company and the number of followers you have. What I'm waiting to see is the next case that comes along and applies Justice Finkelstein's reasoning. And what would be interesting is if liability was contested on the basis of knowledge. So that sort of first hurdle, I didn't know that it was on my Facebook page. But perhaps I'll leave it there and pass it to Chris.
The next panel member is Bill Doogue. Bill is an accredited criminal law specialist who's been practicing for over 20 years. His firm, Doogue, O'Brien & George, has 7 criminal law specialists in it, and all 13 solicitors practice exclusively criminal law.
The disasters of social media for us are heavily outweighed by the benefits, and the starting benefit is information. Avoiding disaster while tweeting, my opinion would be that you tweet what you want, and it's the same as posting. You post what you want. Either you have a well thought out position or you don't, and either you're willing to stand by what you say or you don't. And the only caveat on it is that if you wouldn't put it in a letter, don't put it on social media. If you don't understand Twitter, if you don't understand Facebook, if you haven't heard of Instagram, if you don't know about Foursquare or location-based services on the net, you're doing your client a disservice. They're all incredibly powerful things that come up all the time in court cases. Get onto it. It's really simple and it's quite a lot of fun. And if anybody has any questions, feel free.
Where are we in Australian law in terms of the view as to whether retweets constitute endorsement?
I suppose that applying that test that from the Allergy Pathway case, they could constitute an endorsement. If there's something actionable in the tweet to begin with, and you know that perhaps it's untrue or something, and you've got the power not to pass on that tweet, by passing it on, you're endorsing it and you're potentially liable for anything that's actionable in it.
Is it feasible to have provisions that the supervisor can go into the system and see what the employee has been doing in terms of meeting the obligations of the HRAD Act? And secondly, if the employee is doing private communications, is it appropriate for the supervisor to be able to do that, or does that raise Privacy Act problems?
I'm glad you raised that. We are in the process of reforming the privacy law at the moment, which doesn't really answer your question currently, but there is this new private cause of action that's being mooted by the current government. The IHS Act, it says that employers must monitor conditions.
I could add a few comments to that also. I read last night that the big issue of social media is in relation to recruitment. And it's standard practice for a lot of recruiters around the world when vetting candidates to right away go to their social media pages. I'm not going to go into detail, but it does raise some of those questions in terms of privacy. And one that I found interesting was discrimination. I'd just like to thank the panel, and before I do, I would like to just say that it was really great to have this broad discussion. I'm hearing from all different sides of the legal profession, different specialty areas, as well as the questions. I think were fantastic, and it just is a real testament to the breadth and the range of issues and implications social media is having, and especially will have in the very near future. So if we could thank the panel together for their time.